I don't have a court order. What should I do for parenting time? Hi, I'm Bill Farias, founder of Farias Family Law. And this is a question that I got last week from a gentleman who's been separated from his wife for about a year and a half. He has two children, ages 5 and 3. He's not happy with the current parenting arrangement, and he wants to know what he can do about it and how to make the changes that he wants. And so the best way to think about this is that first, in determining a fair parenting plan, the court is going to take into consideration a number of factors. The children's bonds with the respective parents, where the parents live, what the parents' work schedules are, where the children are rooted in terms of community. Do they have activities in that community? Are there family members nearby? What's the better school system for them? And a number of other factors. But one factor that's not actually listed in the statute, the law that breaks down the considerations for a court, is precedent. In other words, if you end up going to court to address a parenting issue, one of the first questions that most judges will ask is, what have the parties been doing? So what plan has been in place in between the time that the parties split and they end up in court? And that's important because unless it requires some change for either reasons of scheduling or there's an issue with one of the parents, but if you put that aside, a judge may go with something along the lines of what the parties have had in place. In other words, it serves as a precedent. If you have a split and for a period of months and months, or in this case, almost a couple of years, where the parties have a certain arrangement in place, that arrangement is going to be taken into consideration by the court in deciding what the court should do going forward. And so if you have a parenting plan in place that you don't like, or you don't have any plan in place at all, and you can't come to an agreement with your spouse on what that should be, then you want to talk to an attorney to determine whether filing is in your best interest. You do not want to be sitting in a parenting arrangement that you are not comfortable with for a long period of time, because it may be difficult to convince a judge to change that, especially if it's been in place for a significant period of time. And that's because judges don't want to disrupt children. So if something's been in place for some period of time for the kids and there isn't a real problem with it, then the judge is not going to be inclined to make significant changes. So that's something to keep in mind. Look at what's in front of you in terms of what parenting arrangement you have in place. What are the prospects of coming to an agreement on what you want? And if the answer to that is the prospects are not good or you're not happy with it, then you may want to talk to an attorney to determine whether you should file to have this addressed sooner rather than later, because you do not want to build that bad precedent. The other thing to keep in mind is to be cordial, to be civil. Even if you do not have an agreement in place or you're not happy with the parenting plan, the court is going to consider how the parents handle this. I mean, first of all, it's not good for the kids for there to be strain and conflict. So putting aside what a judge would think, you want to make this transition as smooth for them as possible, and injecting strain and conflict is not going to do that. And in fact, what it's going to do is it's going to show the court that you have some, or that at the very least, you're not putting the children first. So that is another thing to keep in mind. So you don't have a court order. What should you do for the parenting plan? Don't sit in a bad parenting plan, or at least a parenting plan you're not comfortable with, for a significant period of time. If you're not sure whether it's appropriate, talk to an attorney about it. And don't forget to always be respectful and cordial to the other parent. Even if they're firing bullets at you, you want to take the high road. You want to do it for the kids. It'll be better for them, and it'll reflect well on you when you end up in court. If you have any other questions about this, you can call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel and share it with anyone you think might benefit from it. And you can also find us on Facebook and Instagram at Farias Family Law. Thank you. Have a good day.